Inside Sources.
We're looking at some new legislation, or at least some proposed legislation from the interim session that we've had over the last couple of days, and these are bills that may or may not come up in the general session, but there have been a slew, Holly, of cases just even since we've started this show. At Halloween party, a 19-year-old man was arrested in connection with the killing of two 17-year-olds at a Halloween party in West Valley City. A 16-year-old accused of shooting and killing three people, including a pregnant woman and an infant, at a West Valley City carnival over the weekend, was charged, over several weekends ago, was charged as an adult. And we've had a number of 16 and 17-year-olds. I don't know why this was the summer of the teenage shooter. They were charged as adults, and a lot of people would ask the question, okay, you have an adult jail and you have a juvenile jail. Where do you house the person? Where do they sit while they're facing these charges? And under this bill, the current law would change, and the current law states this, that a 16 or 17-year-old accused of, or convicted, I should say, of an aggravated murder will serve their time in what's called secure care, which is juvenile detention, until they're 25. In other words, the juvenile system will keep their hooks in them until they're 25. Then they can go into the adult system. Under this new bill, because the current law says you're charged as an adult right from the beginning, this bill would say, and you're going to be treated as an adult right from the beginning and held in an adult facility. Now, interestingly, the current law deals with 16 and 17-year-olds who can be charged directly as an adult, but this tweak, this provision for where they would be housed, only relates to 17-year-olds. I'm not sure why that distinction.
Well, probably because they're close to 18. But
right. Yeah. Right.
So just remind our listeners the difference between aggravated murder, for example, and quote-unquote regular murder.
Yeah, so that's a great question. So aggravated murder is the crime in Utah that carries the death penalty. There is a law in the United States of America that you cannot execute a minor. So the death penalty does not apply to 16 or 17-year-olds, period.
Yeah.
Now, but the aggravated murder punishment can include life in prison without the possibility of parole. I haven't answered your question yet, but an aggravated murder is a murder with an aggravating circumstance. In other words, a knowing and intentional killing of a person, but something else was going on, like an armed robbery, or maybe two people were shot, or maybe it was a murder for hire or something. We have like maybe 20 or 25 designated aggravating circumstances that can bump a murder into an aggravated murder. And again, that's where you'd have like a 25 to life or a life without, that type of thing. And so people who are convicted of aggravated murder in Utah, even though it can be 25 to life, I'm not familiar in my short 43 years anyone of those ever getting out of prison. But there's always the chance that that could happen.
So it's interesting to me, you've mentioned there were a number of 16-year-olds over the summer, and they've been charged with aggravated murder. I think if I remember one case, and it might have been the Ben Lomond case,
exactly,
where there were like 25 shell casings or something.
Right,
like,
that's another.
It was, like there was a lot. That would have been the aggravating factor, right?
Right, and also that other students were in the line of fire. That other people could have been hurt. So that's an aggravated murder case. But again, that's a 16-year-old.
Right. So this new proposed law wouldn't affect that.
Would not affect that. So that makes me wonder why they're doing this. I mean, and maybe it's one of those baby steps things. Maybe it's one the legislature saying, "Hey, let's just go grab this 17-year-old group into the adult system for this specific crime of aggravated murder." I don't even know that you get a lot of pushback on that, because aggravated murder does mean that the murder was done in an especially heinous way, or especially depraved way. You know, it's something that makes it more than just a murder, which is awful all by itself. So maybe the legislature is saying, well, let's see how far we can get here with this 17-year-old group. And frankly, a lot of my friends in the juvenile court system might push back on this. It is a little concerning that you keep a kid in the juvenile system until they're 25, which is really largely rehabilitative, and then you put him in the adult system, sort of throw them to the wolves. And I don't mean to be critical of the adult system, but they're different. And I do support the notion of keeping young offenders in the juvenile system as long as possible. 25 seems like a long time. I guess they could have made that 35 or 40. Instead, they said, we're not even going to go to 25. you're 17, you're going to the adult system right away.
Right, and I wonder too, because it seems to take a fair amount of time for cases to wind their way through, if they're going to be 18 anyway by the time they hit sentencing.
And
anyway,
that's the rub, and that happens a lot.
Yeah.
So that you get to that. I mean, no, they're almost always 18 by the time they get to sentencing.
Yeah.
And so then the judge is like, why am I dealing with juvenile detention? It's because you look at the age of the crime at the time that you committed it.
Yeah, it's interesting. So this is part of a proposed bill. It doesn't even have a named sponsor yet, but it was presented in the Judiciary Interim Committee this past Wednesday. And because of the way the process works, right, they had an opportunity to discuss it. That'll be officially presented during the 2026 general session that starts in January.
Yeah, and we talk about the bill got some notoriety because of the 17-year-old housing a 17-year-old who was tried as an adult in an adult facility. It also allows the prosecution to file a motion with the Board of Pardons and Parole regarding provisional housing of a minor in secure care. So it allows the not just the jail or the sheriff to decide, but the Board of Pardons and Parole to decide where some of these offenders will be. But it does another thing. It creates amends this definition of what we call the recidivism standard metric. And this is a complete digression from where we've been, but it's part of the same bill.
Part of the same bill, yeah.
And so what it does, the recidivism rate, is what we think about a lot, the revolving door, the problem with the criminal justice system and juvenile justice system. And to the extent that they are redefining how that's looked at, I think is a good thing, because we sort of cherish the juvenile justice system as a way to help so that we don't have people come back in the system.
Right.
Let's work on rehabilitation. Let's work on ways to hope that we don't have to get you into the adult system, because the adult system, unfortunately, has become a system of not warehousing, but there's not a lot of programming available like there is in the juvenile system.
Mm-hmm.
And sometimes people they're just doing their time, let's face it. And so I think there's a different use of time in the juvenile system, the adult system, and maybe, understanding recidivism and how to keep people from coming back into the system. I mean, that's always a big part of the criminal justice system in general.
There's another bill that they talked about, actually, which I think is interesting too, because you're talking about the justice system, and this bill is a specific response to what lawmakers called an egregious Supreme Court ruling. It did not have to do with redistricting, which I'm sure that's coming, but it had to do with first responders, actually. So there was a ruling in August from the Utah Supreme Court that said Unified Fire Authority was not immune from a lawsuit stemming from a 911 call, but the lawmakers are like, absolutely not. That was egregious. We should not allow that to stand. And so they unanimously approved this interim committee, which means it's not law. It still has to go through the official process. But it's to put first responders under governmental immunity, which protects them from lawsuits for doing their job.
Yeah, and a lot of people think they already are under sort of a Good Samaritan type liability.
And that's different. Good Samaritans for like citizens.
Good Samaritan is for a Good Samaritan, not for a first responder who's there in the line of duty anyway. But I work as a first responder, and so I'm a little bit biased. I'm on the ski patrol, and I do legal work for the National Ski Patrol, and this is always an issue that comes up. I've done that for 42 years, and I haven't been sued or seen patrollers get sued very often. But people are always like, "Well, SCOTUS, what can I do this, and what if I get sued for that?" I always say, do your job. I mean, your patient care, as you know from your own professional experience, is number one. Worry about the rest later. But if you're doing what you think under your training is the best thing for patient care, you don't have to worry about it. But again, and I think the legislature was concerned about what the Supreme Court was doing to these fire authorities, saying, hey, wait a minute, they're doing everything they can, and suddenly they're getting sued.
Look, the person sponsoring the bill is Casey Snyder, who's in leadership, and he called it judicial incompetence, judicial activism, and said our Supreme Court has made our communities less safe. So tell us how you really feel.
Yeah. These judges these days, they're just becoming political activists. Not. But anyway, sometimes we don't like what they do, and the legislature has been sort of reactive to that more than we've seen in the past.